We have to really look at the issue of race and voir dire if we want to do justice by our client. That first case that we tried in 2009, we didn't voir dire on race because we didn't think race was an issue. But apparently, prosecutors see race as an issue in every criminal case when a defendant is black or Latino. Batson versus Kentucky. This is a case that came out from the Supreme Court in 1986. Thurgood Marshall authored an opinion. He suggested that we needed to get rid of peremptory challenge. He thought that it was so dangerous that we couldn't trust prosecutors with it. When thinking about a Batson challenge, we can't be surprised. We've got to anticipate discrimination. Making a Batson challenge, you've got to take good notes during jury selection. You've got to track demographic information, different variables, the questions that are being asked to jurors. I usually use the jury questionnaires to chart a lot of information. If I've got an African-American man, I'm going to note he's an African-American man. I might also note his age. I might also note where he lives. And I'll do the same thing for every juror. Prosecutors often ask, what do you favor, punishment or rehabilitation in the criminal justice system? I'll write them all down and chart all of these different things that I know that prosecutors usually use to justify their peremptories. And I can look at it and say there's an inference of discrimination because there's some disparate treatment between numbers 5 and 2. The only difference was race. You've got to first state on the record that your client is a member of a protected group. Second, you want to point out that members of his race were removed and object to their removal. And then you want to point out any aspect of voir dire that supports an inference of discrimination. Your next step would be to take steps to preserve the issue for appeal. Don't get to trial and be surprised when you have an all-white jury seated. Be ready before you get to trial